I guess we'll get started and we'll have our bailiff call the case. And then I'll let you guys state your appearances for the record, okay?
Welcome to the 2024 Bales Competition. Calling the case to order, State of Eureka versus Jackie Liu. The Honorable Judge Abraham presiding.
Thank you. So I'll have you state your appearances with the prosecution going first. And if you could give me your name and your pronouns, that would be wonderful. I'll start. The prosecution, I imagine, is here. Okay,
Yes, Your Honor. Good afternoon. My name is Grayzel-Ward for the people, and I use they or she pronouns.
Okay.
Your Honor, Lande Watson for the people. I use she or her pronouns.
Okay, go ahead.
Good afternoon, Your Honor. My name is Leah Mandani, and I use they, them pronouns.
Okay. And is that's pronounced Leo?
Leo, yes.
Okay, Leo.
Hello, Your Honor. My name is Samahria Alpern, and I use she, her pronouns.
Okay. Okay, you may take a seat. And I imagine the people have an opening statement they want to start.
Before we begin,
Yes.
can we go through a few housekeeping matters?
Sure.
First of all, I would like to ask about your courtroom preferences. May we move about the well? When should we ask permission before approaching the stand or the bench?
So in keeping with traditional practice, I'd like you to ask permission to approach a witness. You don't have to give the document to the bailiff, but I'd like you to show the document first to opposing counsel. And if you have a courtesy copy for myself, that would be helpful. And so I think, yeah, that's what I would like you all to do.
And as far as movement about the well, is that permitted?
Yes, you can move about the well. You don't need permission for that. And I just want to make sure, though, I know that there's kind of some theatrics with trial, but I do want you to respect the kind of personal space of the defendant. And so as long as you're not in their space, we'll be fine.
Yes, Your Honor. And with regards to that, would you like us to address our statements to the judge and the jury, to just the jury?
Your statements as far as your opening
and closing statements, Your Honor.
I'd like you to do it for both the judge and the jury.
And at this time, the people move to invoke Rule 615, calling for the constructive sequestration of all witnesses, barring party representatives. Our representative in today's case will be Officer Jean Caller.
No objections, Your Honor. Our party will be to defend herself, Jackie Liu.
Okay, that sounds good then.
We also have a good faith-based belief that on our direct examination, we will be admitting Exhibit 2A, that's the picture of the car, and we ask if we have permission to hold up this exhibit during opening statement.
Your Honor, we do intend to object to the entry of this exhibit, and we ask that we hold off on showing it to the jury until it's entered into evidence.
That's fine. We'll do that with the defense said.
Yes, Your Honor. And at this time, I would also like to direct the court's attention to a few stipulations and ask to read them onto the record.
Sure.
I would like to draw your attention to Stipulation 3B. An accident scene construction report was completed in this case, and it determined that the driver of the burning Ford Fusion in this case was driving the vehicle at 85 miles per hour shortly before the accident occurred. Tire tread markings show that the vehicle swerved suddenly to the left during a bend rightward on the road. The driver overcorrected to the right, braked hard, and ran up onto the curb under an overpass, hit the concrete wall of the overpass. The car caught fire shortly thereafter, burst into flames. 3E, the posted speed limit sign on this entire stretch of highway was 55 miles an hour. And Stipulation 5, the parties agree that on the early hours of the morning on June 21st, 2021, the burning Ford Fusion found at the scene by the police officers was owned and registered to Jackie Liu.
Okay.
And with that, the people are ready to proceed.
Okay, and I'll enter those stipulations. I imagine, because the stipulation, you both agreed to these. Okay, thank you very much for helping me with the housekeeping matters. Do you have any things you have to
Your Honor,
address?
just one quick housekeeping matter from
Of
the
course.
defense. We'd like to ask the court for judicial notice of the statement of probable cause. That is the fourth document in your binder, specifically the first line of the fourth paragraph, which reads, Hospital records revealed victim suffered 3 fractured bones in her right foot/ankle area.
Is this with the agreement of the prosecution?
Yes, Your Honor.
Okay, so for that reason, I will take judicial notice of that line.
And with that, we're ready to proceed.
Okay, thank you. So we'll start with the prosecution and their opening statement.
Yes, Your Honor.
Okay, you may begin.
Your Honor, members of the jury, may it please the court. Her car, her keys, her crime. Members of the jury, today you're going to learn that on June 21st, 2021, the defendant made the decision to drink. To drink too much, far beyond the legal limit, and then to drive. To drive too fast, far beyond the speed limit, and crash, injuring Miss Justine Chow. It's her car. It's her key. It's her crime. It's a Sunday night in the middle of June, and Miss Chow and the defendant, they decide to go out to a party. They want to let loose and they want to have a good time. And just like all of us before we decide to go out and have a good time, well, it's important to make a plan. And you see, you're going to learn that's exactly what happened today. The defendant was to be the designated driver because, after all, it was her car. And Miss Chow didn't even have a driver's license. So it's the end of that night. Miss Chow has been wearing high heels all night long. She's ready to take them off the minute she gets into that passenger seat. She's ready to put on her pajamas the minute she gets home. But it will be a long time before that happens. Because you see, that night, as Miss Chow takes her predictable spot in the passenger side of the vehicle, well, the defendant, she steps into the driver's seat. You're going to learn today that as the defendant gets into the driver's seat of that car, she's been drinking. You're going to learn that her blood alcohol concentration, or BAC, it wasn't the legal limit of 0.08. It wasn't twice the legal limit at 0.16. Members of the jury, you're going to learn today that the defendant's blood alcohol concentration was almost 3 times the legal limit at 0.21. Now we're back in the car that night, the defendant's car, and she's weaving down the road in the wee hours of the morning. Miss Chow is gripping onto the passenger seat. Why? Because she's scared. The defendant is flying down the road. They fly by a speed limit sign that says 55 miles an hour, but the defendant's not driving 55 miles an hour. She's not driving 65 miles an hour. She's not driving 75 miles an hour. She's driving 85 miles an hour when all of a sudden, swerve to the left, overcorrect to the right, and crash. They hit a concrete wall. Miss Chow's body is flung against the passenger's door, her right ankle taking most of that impact. They barely make it out of that car alive before it bursts into flames. Scrambling out of the car, Miss Chow leaves one of her shoes in the passenger seat. When she gets out of that car, her right ankle is broken. And the keys to that car, they're in the defendant's pocket. And because of the defendant's actions that night, that we the people have brought 2 charges in today's case. 1, aggravated driving while intoxicated, and 2, criminal vehicular operation. Now, those legal terms boil down to just 3 things in today's case, 2 of which have already been stipulated. That 1, the defendant's blood alcohol concentration that night was at least 0.16, which both parties have agreed to. That 2, Miss Justine Chow sustained injuries that night because of the crash. Again, both parties have agreed to that. All that leaves is 3, that it was, in fact, the defendant who was driving that night. Now, we, the people in today's case, have the burden of proof beyond a reasonable doubt. And we embrace this burden because the defense, they're not going to be able to provide any reasonable doubt. Now, you don't have to take my word for that. Today, you're going to hear from the officer who responded to the scene of the crime, Miss Officer Jean Collar. She's going to come to the stand today and tell you exactly what she saw. That when she first approached the scene, things were chaotic. She couldn't get the right story. She had a hard time understanding what really happened. But she talked to each suspect alone. When she talked to Miss Chow told her exactly what happened that night. That the defendant was to be the designated driver, and indeed she was. That Miss Chow didn't even have a driver's license. That it was the defendant's car, that at the end of the night, those keys could be found in the defendant's pocket. You're also going to have a chance to hear from the defendant herself today. She's going to come to the stand and tell you that she was drinking. She's going to come to the stand and tell you that that was her car registered to her. She's going to come to the stand and tell you that at the end of the night, her keys were in her pocket. Members of the jury, you're going to learn that this was her crime. Now, in a moment, defense counsel is going to stand before you, and they're going to give their opening statement. They're going to try to point fingers elsewhere. They're going to try to distract you. I want you to listen closely to the story defense counsel is going to try to tell you today. I want you to ask yourself, is their story reasonable? It's the defendant's car. It's the defendant's key. It's the defendant's crime. Which is why at the end of today's trial, my co-counsel, Lande Watson, is going to stand before you and ask you to find the defendant guilty. Thank you.
Is defense ready to provide an opening statement?
Yes, Your Honor. Convenience over justice. That's what this case is about. My client, Jackie Lou, did not drive drunk. So why is she sitting here in front of you charged with doing so? Because her friend, Justine Chow, lied to the police. Justine Chow crashed Jackie Lou's car and then lied to save herself. The police believed what they wanted to hear, and they ignored the rest. Members of the jury, today you will learn how the state, the police, and even Miss Lou's own friend, Justine Chow, chose convenience over justice. But this trial is not about convenience. It's about the truth. The truth is that Jackie Lou is innocent. Let's go back 3 years to the early morning hours of June 21st, 2021. Jackie Lou and her good friend Justine Chow are heading home from a party. As the evidence will show, Miss Chow gets in the driver's seat of Miss Lou's car. Minutes later, 2 police officers come across that car, smashed against the concrete wall of a highway overpass, completely engulfed in flames. 2 people are sitting on the side of the road a few yards away from the wreck, Jackie Lou and Justine Chow. And as the police get closer, they notice that they both seem drunk. Sitting there on the side of the road, covered in blood and glass, next to a burning car, Miss Lou is in shock. She'll tell you today how scared she was feeling. But that fear only sinks deeper into her stomach when she sees that the police officers who she thinks are coming to help her in one of the worst moments of her life are laughing. Frightened and trying to protect her friend, Miss Lou makes a mistake. She'll tell you today that she panics and tells the police that neither of them were driving. Miss Chow tells the police the exact same thing. But as the evidence will show, as soon as Miss Chow is alone with the police, she tells a new lie. She accuses Miss Lou of driving, a convenient story because she knows that the car is in Miss Lou's name and that at that point, Miss Lou is holding the keys. And so, as the evidence will show, the police take the easy way out. You'll learn how after conducting an investigation that does not even last a single hour, the police choose convenience and arrest Jackie Lou. But how can the police make this arrest? You'll learn that this is not a normal traffic stop where the police pull over someone who is driving unsafely. This is not a normal traffic stop where the police walk up to the driver's side window to question the person sitting there. This is not a normal traffic stop where the police see who is driving. Officer Collar, the lead investigator in this case, will tell you when she takes the stand today that she and her partner never saw who was driving. And she'll tell you that because of that, she starts her investigation with 2 suspects. But as you'll also learn from Officer Collar's testimony, in the absence of seeing who was driving and with 2 suspects, each claiming that they weren't the driver, Officer Collar fails to ask all of the tough questions and she fails to collect all of the evidence. As the judge will instruct you today, what this case comes down to is who was driving the car when it crashed. And the state has the burden to prove to you that beyond a reasonable doubt, Jackie Lou was sitting in that driver's seat. Beyond a reasonable doubt is the highest burden that exists in our legal system. It's a higher burden than what the state needs to take your child away. And it's so high for a reason. It exists so that no person will be convicted of a crime unless the state has enough evidence to prove that they are guilty beyond a reasonable doubt. The evidence today will show that the state cannot meet that burden. Because if the police had conducted a full investigation and paid attention to all of the evidence, Justine Chow, not Jackie Lou, would be sitting here today. So throughout today's trial, members of the jury, I ask that you not ignore any of the evidence. Despite what Counselor Grayzel-Ward told you, I'm not asking you to be distracted. In fact, I'm asking you to pay attention to all of the deficiencies in the state's case. Pay attention to whether there is a single credible person who can place Jackie Lou in that driver's seat. Pay attention to the physical evidence, which will show that Miss Chow broke her right ankle in the accident because she snapped it against the car's pedals. Pay attention to Miss Lou's testimony of how Miss Chow handed her keys back to her after the accident and then told the police exactly where they could find them on Miss Lou. And pay attention to whether Officer Collar conducted an equally detailed investigation or any detailed investigation at all against both Miss Lou and Miss Chow. And if you pay attention, you will see that Jackie Lou is innocent. Despite the state's scarce evidence against Miss Lou, her car and her keys, and the undisputed fact that the police never saw who was driving, the state would like you to believe that they know. How convenient. So every time the state comes up here today and shows you a piece of evidence, I want you to keep a question in mind. Does this place Jackie Lou in the driver's seat? Members of the jury, you are sworn to the most solemn duty that exists in the American legal system. Unlike Miss Chow, unlike the police, and unlike the state, you cannot choose convenience over justice. That's why, at the end of today's trial, my co-counsel, Leah Mandani, will ask you to return the only just verdict: to find Jackie Lou not guilty. Thank you.
Thank you. The prosecution, do you have your first witness?
Yes, Your Honor. The people call Officer Jean Collar to the stand.
Okay, thank you.
Can you please introduce yourself to the jury?
Hi, my name is Jean Collar.
And what do you do for a living?
I am a police officer with the Lande Police Department. I'm also a member of the Lande Safe Streets DWI Task Force.
And what training did you have to receive to hold your position as a police officer?
Yes, so I received my bachelor's degree in criminal justice from Eureka State University, and then did a 5-month training with the state, an additional 8 weeks with the city.
And did any of this training include training specifically for addressing cases of driving while intoxicated?
Both the state and local levels of training involve DWI investigations, but I furthered this training taking over 200 additional hours in DWI investigations training for both alcohol and non-alcohol intoxicants, and have used this training in over 500 DWI cases.
Your Honor, the people moved to enter Officer Jean Collar as an expert witness in the field of driving while intoxicated investigations.
Your Honor, we object on lack of foundation. May I be heard?
Yes.
We've heard that Officer Collar is trained in conducting DWI investigations, but we haven't heard anything else about how she is qualified to testify as an expert. We have not heard what materials she's considered, whether those materials are sufficient, what method she used, whether that method is standard or has been peer reviewed, whether she applied the facts of this case to her method reliably. Without hearing that foundation, they cannot enter Officer Collar as an expert.
So far the witnesses testified to their training. Have they testified as to how many investigations they've actually conducted?
Yes, Your Honor. Officer Collar told us that she has done over 500 investigations.
Okay. I think some of the questions that you're bringing up will go more to the weight of her expert testimony, which you'll have an opportunity to cross-examine on her.
I will, Your Honor.
So I'll let her be determined a expert witness.
Yes, Your Honor. Officer Collar, I want to talk to you about your investigation on the night of June 21st, 2021. What were you doing that evening?
I was on patrol, like I normally am on the weekend evenings, when I came across a burning vehicle at the side of the road, and so I pulled over to investigate.
After you pulled over, what was the first thing you did?
I turned on my body cam footage, which is standard protocol for the department whenever we're responding to an incident.
Your Honor, permission to approach the witness with what has been pre-marked as Exhibit 1 and Exhibit 2A?
And I imagine the defense has already seen these exhibits?
Yes, Your Honor.
Okay, thank you.
Okay. Permission to approach the bench?
Yes. Is this a courtesy copy
2A?
for me?
Yes,
Okay.
Your Honor. And Exhibit 1?
Okay, thank you.
Approaching the witness?
Yes.
Officer Collar, I'd like you to direct your attention to what has been pre-marked as Exhibit 1. Do you recognize this document?
I do.
And what is this document?
It is a transcript of the body cam footage from that night.
Your Honor, at this time, the people move, sorry, Your Honor. Is this a true and accurate copy of the transcript?
It is.
Your Honor, at this time, the people move to enter Exhibit 1 into evidence.
We object, Your Honor, specifically to Ms. Chow's statement under 403, more prejudicial than probative, or rather more misleading than probative. Ms. Chow is not a witness in today's trial, and we don't have an opportunity to cross-examine her. If the officer wants to talk about what her investigation entailed when talking to Ms. Chow, that's, of course, we don't object to that. But to enter this document in when Ms. Chow is not here to testify herself, that would be more misleading than probative.
And that also would be hearsay, correct?
Yes, Your Honor, but except for in this jurisdiction, we don't have hearsay rules.
Oh, forgive me. So.
May I be heard?
Of course.
Your Honor, this is a transcript of the events of that night. It contains the only true and full copy of what was said in Officer Coller's investigation. The defense is likely very interested in what happened in this investigation, and as Ms. Chow is not able to testify today, this is very important for the jury to be able to see what Ms. Chow actually said. If the defense wants to cross-examine the witness about that interaction, we can learn more about it.
So ordinarily, the witnesses testify to what they observed in their investigations. And when we have the witness here, why would we rely on the transcript of a body-worn camera footage? So I think we should. I'm going to agree with the defense's objection to entering this into evidence when we have the witness here and they can testify as to what they learned in this investigation.
Your Honor, in light of that, is it still possible to, at a later point, try to enter specific lines, or would you not like anything from the transcript?
I'm happy for you to try again if you want to, but for right now, let's ask the witness some questions.
Yes, Your Honor. Approaching the witness to take Exhibit 1. And
And
Officer...
that can be, of course, used to request recollection if she needs to.
Yes, Your Honor. Officer Coller, I'd now like to direct your attention to Exhibit 2A. Do you recognize this?
I do.
And what is this?
This is a picture taken from the body cam footage of that night. It is one snapshot of the body cam video.
Is it a true and accurate copy?
It is.
Your Honor, at this time, the people move to enter Exhibit 2A into evidence.
And I reject this exhibit as well under 403 once again. This picture of the image on fire has no probative value in today's case. The only concern and only element is who was driving that car, and this photo is taken after the crash. It only serves to literally inflame the passions of the jury with a physical image of the car.
You have an answer to that?
Yes, Your Honor. This is a photo of the crash that Officer Coller came upon. This is important for the jury to see what the scene of the crime looked like from the perspective of Officer Coller and her body-worn camera.
And can you tell us what the probative value of it is
Yes, Your Honor.
in determining what the elements in question?
Your Honor, this goes more to the investigation that Officer Coller conducted, the dangerous scene that she came upon when she arrived at the crash.
May I respond?
Yes.
Your Honor, there is a less prejudicial way to go about what Ms. Watson was explaining. Officer Coller can testify what she saw herself when she entered the scene of the crash. Showing the jury this image taken from a body cam footage has no probative value. It only inflames the passions of the jury against our defendant.
So I'm going to have to agree once again with the defense. I think this has very little probative value in that we're trying to determine who drove this car on the day of question, and kind of the ancillary issues of this car and whether it was on fire or not really doesn't help the jury come to the ultimate. It doesn't help the jury determine the ultimate question for them at this point. And it is a little inflammatory in that it seems like a very serious accident happened here. But I think that the officer can testify as to if it's probative or it's relevant, what the scene was around this accident, if you think it was relevant. But I think at this point, this picture, its probative value is much more outweighed by its prejudicial effect.
Yes, Your Honor. Permission to approach the witness
Yes.
and retrieve Exhibit 2A. Thank you. Officer Coller, I want to talk to you about what you saw when you arrived at the scene of the incident. What did you see when you approached the burning car?
As we approached, there were two individuals sitting off to the side of the burning car, about 10 yards from the car in question, and they were talking to each other, swaying slightly.
Could you hear anything they were saying?
Not from far away, we parked a ways back, but as we got closer, their voices started to be able to be heard, and I heard Miss Chow say that she couldn't even believe she was alive.
What was the first step of your investigation?
First and foremost, we want to make sure that the individuals were safe and uninjured. It was clear that there was an incredibly serious wreck. The car was on fire, and there were some small lacerations from glass on their bodies. But I wanted to make sure that there was nothing more serious happening, and so that's when I asked if they were all right. The defendant said that they were fine, and that's when Ms. Chow told me that her ankle was broken.
Officer Caller, now I want to talk to you about what Ms. Chow and the defendant told you happened that night when they were together. What was their account of that night?
The defendant quickly said that they were not the ones driving, they being both Ms. Chow and the defendant. And Ms. Chow corroborated that story and pointed up this embankment, which was a steep slope rising for about 30 feet topped with a 5-foot tall guard fence. And then the defendant joined in pointing up said fence.
What else could Ms. Chow and the defendant tell you about this third person?
Not much. They couldn't even decide on the gender of the third driver. The defendant identified the third driver as a woman using she pronouns, and Ms. Chow used he pronouns to identify this third driver.
So they couldn't agree on the pronouns of this third driver. What was your next step?
Because the story wasn't clear per company or per departmental protocol, we wanted to separate the two suspects.
And who did you talk to first?
That's when the paramedics were arriving. So as I took Ms. Chow to see the paramedics, I talked to her first.
Officer Caller, now I want to talk to you about what Ms. Chow told you when she was separated from the defendant. How did Ms. Chow seem?
She seemed upset to me. She was crying, visibly shaken. But she said that she wanted to talk to me and that the defendant was driving, that she didn't want to get the defendant in trouble in front of them.
What else did she tell you about that night?
She said that the defendant was supposed to be the designated driver. It was the defendant's car, and Ms. Chow, didn't even have a driver's license.
What was your next step?
After talking to Ms. Chow, I knew that I wanted to talk to the defendant to see what she had to say.
Officer Caller, now I want to talk to you about your conversation with the defendant when she was separated from Ms. Chow. What was the first thing you said to the defendant?
I further checked in because she wasn't being seen by the paramedics. I asked her again if she was doing all right, and she said she was.
And what was her account of the night?
She continued to tell me this story of the third driver, but wasn't able to provide any additional details about the gender, name, or anything more about this mysterious third driver.
So the defendant couldn't tell you anything more about this third driver. What did she tell you about the plans for that evening?
Well, they had gone to a party and they had been drinking. The defendant said that they had 1 or 2 drinks, but I knew that wasn't the case because the defendant was slurring their words and smelled of alcohol. And I know that just doesn't happen after 1 or 2 drinks.
What was your next step?
I told the defendant that I had enough to arrest for probable cause DWI because I had an eyewitness testifying of that fact. Ms. Chow had also told me, in addition to the fact that the car was licensed or registered in the name of the defendant, that the keys would also be found in the defendant's pocket. And with all of those facts, I had enough to arrest, and I told the defendant as such.
How did the defendant respond?
The defendant had been becoming increasingly agitated throughout the investigation, not consenting to a field sobriety test, and it took a while to even get them to tell me their name. But at this point, they became increasingly agitated and told me that it was in fact Ms. Chow who had been driving the car.
Objection, Your Honor, to specifically increasingly agitated as speculation. Officer Caller can testify to what she saw and what she observed, but to delve into the mindset of the defendant to say that she was increasingly agitated is speculative.
Your Honor may be heard.
Yeah, of course.
Officer Caller is merely testifying to her rationally based perception of the defendant when the officer was talking to her.
I happen to agree with the prosecution. I think you're a human being and you have your sense of when people are agitated or not. So if you don't find this officer to be a reasonable person, then you can cross-examine on her ability to perceive when someone's agitated. But at this point, I'll let it stand.
Yes, Your Honor. Officer Caller, I believe you were telling us how the defendant seemed at that time. Will you please continue?
Yes, so at that point, the defendant accused Ms. Chow of being the driver and telling her to hold the keys after Ms. Chow had been driving.
Okay, Officer Caller, I want to take a step back. You mentioned there was a field sobriety test. Can you tell us about any tests you did on the defendant at the scene of the incident?
Yes, because the defendant did not consent to a field sobriety test, I asked for a warrant to do a BAC draw. It is a test administered at the hospital, which takes the blood of the defendant and tells you how intoxicated they were.
And what is the legal limit for driving?
0.08, anything above that we know impairs one's ability to drive.
Later, when you got the results of the defendant's BAC test, what were they?
0.21.
Okay, Officer Caller, back to the investigation. You were telling us that the defendant was now accusing Ms. Chow. What additional steps did you take?
I again confirmed with the defendant that the facts as I had known them, that the car was registered in their name, the keys were in their pocket, and that they wanted me to believe that Ms. Chow was the driver, and they confirmed that all of that was true.
Officer Caller, what did you do next?
I arrested the defendant for probable cause DWI.
No further questions at this time, Your Honor.
Back to the cross-examination?
Yes, Your Honor. May I proceed?
Of course.
Good afternoon, Officer Caller.
Good afternoon.
Your investigation began at 2:18 a.m., correct?
That is correct.
And at 3:12 a.m., you had already arrested Jackie Liu.
Yes.
From 2:18 a.m. to 3:12 a.m., that's less than an hour, correct?
Yes.
So in less than an hour, you had made up your mind.
I had made an arrest, yes.
In less than an hour, you had arrested Jackie Liu.
Yes.
Now, you'd agree with me that when you conduct a DWI investigation, it's important to be thorough, correct?
Yes.
You want to speak with all the witnesses?
Yes.
And you mentioned on direct examination that you had an eyewitness in today's case. It would be ideal to have an eyewitness in a DWI case, correct?
Yes.
And you also need physical evidence, right?
When available, yes.
And you want this physical evidence because you want to corroborate what the witnesses tell you. Isn't that right?
Yes.
So I want to talk about your conclusions in today's case. When you arrived to the scene of the crash, the car was already on fire, right?
Yes.
There were two people at the scene.
Yes.
One was Ms. Chow,
Yes.
and the other was Jackie Liu.
Yes.
And they were both sitting on the curb when you arrived to the scene, right?
Yes.
So they were away from the car.
Yes.
Officer Caller, you never saw Jackie Liu drive, did you?
Nope.
Now, you had seen Ms. Liu and Ms. Chow at a gas station minutes before the crash, right?
That is correct.
They were standing outside the car.
Yes. Snacking, it appeared.
So again, you didn't see Jackie Liu drive to the gas station.
No.
Question, Your Honor. Relevance?
Do you need to say?
Yes, Your Honor. We are laying the foundation that Officer Collar, in fact, saw out security footage camera from the gas station where it was minutes before the crash. That footage would have shown who was driving.
I think it's very relevant, and since this whole case seems to be about who was driving that day, and I imagine who was driving a few minutes earlier before the accident would be relevant in determining potentially who was driving at the time of the accident. So you can go ahead and proceed.
So, Officer Collar, you never saw Jackie Lou get in that driver's seat at the gas station,
No.
and you never saw her drive away from the gas station.
No.
You did call the manager of that gas station for security camera footage, right?
I did.
And she told you there wasn't any footage from that night.
Yeah, she couldn't explain why the security camera wasn't working that night.
So that's a no, no footage from that night.
No footage.
And despite the fact there was no footage, you never asked any follow-up questions.
No.
You didn't give her a description of Ms. Liu.
No,
Didn't give her a description of Ms. Chow.
I did not.
Didn't ask whether she saw who drove that car into the gas station.
No,
Didn't ask if she saw who drove that car away from the gas station.
I did not.
So despite the fact that you never saw who was driving, when you arrived at the scene of the crash, you had two suspects.
I did.
And one of them was Justine Chow, correct?
Correct.
When you arrived at the scene, she was swaying.
Yes, they both were.
She had bloodshot eyes.
Yes, they both did.
Ma'am, I'm only asking you about Justine Chow right now. She had bloodshot eyes.
Correct.
She had watery eyes.
Yes.
She reeked of alcohol.
Yes,
You believe Justine Chow was drunk.
I did.
You believed you had enough probable cause to arrest Justine Chow.
No.
Ma'am, is it your testimony you did not believe you had enough probable cause to arrest Justine Chow when you arrived at the scene of the crash?
That is correct. I did not have enough probable cause to arrest either suspect, given the very minimal information I had at the time of arrival.
I'm approaching counsel with Exhibit 1, transcript of the body cam footage from that night. Permission to approach the witness.
Yes.
And would Your Honor like a courtesy copy?
I still have my original
perfect.
copy.
Permission to give the jury a copy to follow along?
I don't think I'm going to allow them to have a copy until it's in evidence, and that's still,
Certainly. We will not be
question.
trying it. It's just for impeachment purposes.
okay. So I think they don't need a copy at this point.
Approaching the witness with the same.
Yes.
Officer Collar, I just handed you a transcript of the body cam footage from the night of the crash, correct?
That's correct.
Objection, Your Honor. This document has not been entered into evidence.
Your Honor, we're not trying to enter into evidence. It's just for impeachment purposes.
So I think you can impeach her without, or you can impeach the officer without the transcript at this point.
Your Honor, I believe Ms. Officer Collar told us that she did not think she had probable cause. In this body cam footage, when she arrives at the scene, she says the exact opposite.
So I think what you can do is ask the officer, isn't it true that you said this? And then if it's not, if you can't get what you want in that way, then we can rediscuss whether or not to use the exhibit that's not in evidence, that you asked not to be put in evidence.
Yes, certainly.
Yeah.
Then I'll retrieve the exhibit. Officer Collar, when you got to the scene of the crash, you spoke to your partner individually, correct?
Yes.
And you told him, interview both, identify a driver, and go from there. Neither of them are going to be good enough to do FTCs, but we've got all the probable cause we need to take them in. Isn't that what you said?
That is what I said. However, I would like to draw a clarification. The first step was to identify a driver. Once we had identified a driver, we had enough to take them in, but not before we had identified the driver.
Let's talk about why you didn't think Ms. Chow was a driver. First, you talked a lot about the keys on your direct examination, correct?
Correct.
You told them you found them on Ms. Liu.
Correct.
And on direct examination, you told us that Ms. Liu told you Justine Chow was the one who gave those keys back to her.
Correct.
And Ms. Chow was the one who told you where to look for those keys.
Yes, she said that they were in the pocket where keys go.
She told you the exact location of where those keys would be, didn't she?
Yes.
And I want to talk about something you didn't bring up on direct examination, which is Ms. Chow's missing shoe. When you arrived to the scene of the crash, you told us she was injured, right?
Yes.
To be precise, she had broken her right ankle.
Sure.
And you noticed that she was missing a shoe.
Correct.
You never asked her which shoe she was missing, did you?
No.
Whether it was her left heel
No.
or whether she was missing her right heel.
No.
Now, Ms. Chow did tell you she lost her shoe in the passenger seat,
That is correct.
and you just believed her.
I had no reason not to.
Well, you didn't push back on this claim at all, did you?
No.
You didn't push back at all, despite the fact that everything in that car was burned.
No.
Burned beyond recognition, right?
That is correct.
In your own words, Officer Caller, everything in that car had turned to dust.
Objection, Your Honor. Asked and answered.
I think you've asked the question slightly differently, but I do think we should move on.
We will be.
Okay, thank you.
I'll just get my answer
Thank you,
and move
Attorney.
on.
Okay, yes.
So, Officer Caller, in your own words, everything in that car was turned to dust.
Yes.
Now, I want to be very clear. Even though you told us you believed Ms. Chow was drunk, you never once asked where she was coming from.
Objection, Your Honor. Vague.
I'll let you clarify what you mean by that.
Officer Caller, you interrogated Ms. Chow, correct?
I questioned her, yes.
In your questioning, you never once asked her where she was coming from.
No.
You never asked how many drinks she had.
It was clear that she was drunk. I didn't necessarily need to know how drunk or how many drinks she had had. It was clear that she was intoxicated.
And even though it was clear she was intoxicated, you never asked her how many drinks she had.
No?
You never asked her if she had taken any drugs that night.
No.
You never asked her to submit to any field sobriety tests.
No, it was also not going to be possible to do a field sobriety test on her with a broken ankle.
Well, you also told your partner that it wasn't possible to do a field sobriety test on Ms. Liu, right?
That was before I had been told by the defendant herself that she was fine.
So you had told your partner that, yes?
When we arrived, I thought that it was more likely, at the time, it was more likely that both parties would be injured.
Well, Ms. Liu told you she wasn't good to do field sobriety tests, right?
Yes, and I respected that.
Well, actually, you threatened her, didn't you?
If you would like to, I don't remember that. However, if you'd like to show me something that I could comment on, I might be able to understand what you mean by threatened.
Well, officer, you threatened her to get a sample of her blood, correct?
I don't think that was a threat. It was just I was making her aware of the steps we would have to take next if she was not able to perform a field sobriety test. I would have to get a blood draw warrant.
You told her you would need a warrant for her blood, right?
Yes, that is correct.
Yet you never saw a warrant for Ms. Chow's blood.
No, we only need BAC tests when we're going to be arresting somebody. The only use for a number like that is when somebody's on the stand. I knew that Ms. Chow was drunk, but I didn't think that at the time, after I had gathered the evidence, that she was the driver. And so I didn't need to get a BAC draw or an additional BAC test from Ms. Chow.
So bringing you back to my question, you never sought a warrant for a sample of Ms. Chow's blood.
No.
Sitting here today, you cannot tell the jury what Ms. Chow's BAC levels were on the night of June 21st, 2021.
No, I can tell you that she was drunk, she was intoxicated, but I can't tell you the exact number, no.
Ma'am, that evidence is lost forever.
Sure.
Thank you, Your Honor. Nothing further.
Thank you. If I could just have one moment. Do you have any redirect?
Yes, Your
Okay.
Honor. Officer Caller, why did you decide to arrest the defendant on the night of June 21st, 2021?
Ms. Chow had said that they were the driver, because it was their car, and Ms. Chow didn't have a driver's license. And I corroborated this testimony with the fact that the car was in their name, the keys were in the driver's pocket. And so I had enough to arrest for probable cause DWI.
Objection, Your Honor, specifically to that she didn't have her driver's license. That's outside the scope of the cross-examination.
I think that point's well taken, but I would say that evidence is already, it's already been testified to, so we won't question any more about this license or lack of license. So you can just move on.
Yes, Your Honor. Officer Caller, will you finish telling us why you arrested the defendant?
The facts corroborated the testimony, and I had enough to arrest for probable cause DWI, and so I did.
No further questions, Your Honor.
Okay, does the prosecution have, can the witness be excused?
Yes, please.
Yes.
Your Honor, at this time, the people rest
Okay.
and ask for a brief recess, but before doing so, maybe check in with the bailiff about the time.
Yes, of course. I agree, we should have a recess. I was gonna suggest 10 minutes, if that's okay with everyone?
That works for us.
Okay.
So prosecution has 34 minutes, 35 seconds remaining. Defense has 40 minutes, 57 seconds.
All right, so I guess we'll just start the recess.
Thank you, Your
Okay.
Honor.
All righty, we can resume. Does the defense have their first witness?
Yes, Your Honor. The defense calls Jackie Liu to the stand.
Okay.
May I proceed?
Yes.
Please introduce yourself to the members of the jury.
Hi, I'm Jackie Liu.
How old are you, Miss Liu?
I'm 29 years old.
Can you tell us a little bit about yourself?
Sure. I grew up in the Bay Area, went to UC Berkeley for college, and now I am a freelance graphic designer.
Why are you here today, Miss Liu?
I was arrested after a car accident. I'm being charged with driving drunk.
I want to make something very clear for the members of the jury. Were you behind the wheel when the accident happened?
No.
So who was?
My friend, Justine.
Do you mean Justine Chow?
Yes.
Let's begin with the events that led up to the accident. What were your plans that night?
That night, Justine and I went to a party. It was our friend's 30th birthday.
How do you know Miss Chow?
We met in college, but at the time of the accident, we were roommates.
So you're heading to a party with your friend Miss Chow. Whose car do you take?
I drove my car.
At this party, did you have anything to drink?
Yes. I'm not sure exactly how much, but it was more than I should have.
And how long were you at the party?
A couple of hours, and then Justine and I decided that we wanted to head home.
Did you have a plan on how to get home?
I was supposed to be the designated driver, but I had drank too much.
So what did you do instead?
Justine drove us instead.
Whose car did Miss Chow drive away from the party?
My car.
Miss Chow drove your car. What route did she take?
I'm not sure exactly, but she took the highway.
Now I'd like to talk with you about the accident. I know that this might be difficult for you, so let me know if you ever need a minute. You mentioned that Miss Chow took the highway. What happened next?
She started driving really fast. I started to get scared, and I regretted letting her drive, but we were almost home, so I didn't say anything.
And then what happened?
Justine just lost control of the car. It was terrifying, and I didn't know how to stop it. We ran off the curb and crashed into the wall of an overpass. I thought we were gonna die.
What did you do after Miss Chow crashed?
I was really dazed for a few seconds. Then I came to, and I saw that we were both covered in blood and glass. And then I realized that it smelled like smoke.
What was going through your head when you smelled the smoke?
I thought that the car was gonna catch on fire. I wanted to get us out of there right away.
Were you able to get out?
Yes, we got out just in time.
What do you mean just in time?
As we were running away from the car, it burst into flames. It was so hot and loud. I'm just so thankful we weren't killed.
What did you do after you got away from the car?
We sat down the side of the road. I was really shaken, and I just needed a moment.
How long were you sitting there at the side of the road?
Just for a few minutes, and then a police car pulled up.
I'd like to turn your attention to your interactions with the police that morning. What were you thinking when you saw the police car pull up?
At first, I was really glad that we weren't alone anymore. When we saw the police get out of the car and start walking towards us, we waved at them. I thought that they were coming to help us.
What did you notice about the police as they were walking towards you?
I saw that they were laughing.
How did you feel when you saw them laughing?
Objection, Your Honor. More prejudicial than probative.
Do you have an answer to that?
Yes, Your Honor. Your Honor, this is not more prejudicial than probative. It goes to the defendant's state of mind, which is very relevant. The prosecution opened the door to this based on how they were questioning about her behavior. And so her feelings during the investigation are very probative.
Your Honor, may I be heard?
Of course.
This testimony about the officer laughing just goes to bias the jury against the officer and their investigation. We've already examined and cross-examined the officer about her investigation that night. To talk about how the officer was laughing just goes to bias the jury against the officer and is not probative in today's case about who was actually driving that car.
I certainly agree that it's prejudicial to some degree, but I think it's more probative. And it's more probative because the defense theory of the case is that this investigation was not thoroughly done or not seriously done. And I think their demeanor and how they behaved during the investigation does go to that defense theory. So I don't want you to belabor the point, but I'll let you kind of ask about it and move on from it.
Yes, Your Honor.
Ms. Liu, you were telling the jury about how you felt when you saw the police laughing.
Yeah, it made me feel really uneasy. I didn't think anything was funny. I couldn't understand what they would be laughing at.
Ms. Liu, after laughing as they approached, what was the first thing that the police said to you?
They said, "Good morning." I was so disoriented I didn't even realize what time it was. And then they asked us if we were okay.
What did you tell them?
I told them we were fine, but I was actually so scared.
Did you tell them anything else?
Yes, I wanted to tell them the truth. I wanted to tell them that I wasn't the driver, but I didn't want to get my friend in trouble. So I blurted out that we weren't the drivers.
Was it true that neither of you were the drivers?
No.
So why did you tell the police that?
I knew Justine didn't have her license with her and she smelled like alcohol. I thought that if I protected her and she went along with it, that there would be no way for the police to find out that she was the driver. I was so stupid.
After you told the police that neither of you were the drivers, what did Miss Chow do?
She said that there was another driver, another person who had run up the hill after the crash.
Was that true?
No.
How long did the police speak with you and Miss Chow at that time?
Just a few minutes. We only spent a little bit of time talking about the other person, and then the police stepped away for a little bit.
And how did you feel after that first interaction with the police?
It didn't feel right. I saw them laughing again when they walked away.
I'd like to talk about what happened when the police stepped away from you and Miss Chow. What did you and Miss Chow do then?
We sat down at the curb and waited for the police to come back. Then Justine told me to take my car keys back.
Did you take your keys back from Miss Chow?
Yes, I put them in my pocket.
Did Miss Chow watch you put your keys in your pocket?
Yes, she did.
Why did you take your keys back from Miss Chow?
It was my car. I don't know why she would want to hold on to the keys of my wrecked car. I didn't think much of it at the time.
After you took your keys back from Miss Chow, what was the next thing that happened?
The police came back to us.
Let's talk about what happened when the police came back to you. Did the police ask you and Miss Chow any more questions at that time?
Yes, but they split us up and they spoke to Justine first.
How long did the police speak with Miss Chow?
Couldn't have been more than a minute or two, and then they came right back to me afterwards.
After that brief while, what did the police do when they came back to you?
One of the officers, Officer Collar, started to ask me more questions.
How were you feeling at that point?
I was starting to get pretty frazzled. I was already in shock, not in the right state of mind, so I had some trouble getting my words out.
You were frazzled, in shock, not in the right state of mind. What did Officer Collar ask you?
First, she asked me for my name again, and I thought that I'd already told her, so I said that, and then she said that I hadn't.
Were you ever dishonest about your identity to Officer Collar?
No, not at all, and I even gave her my birthday when she asked.
What did Officer Collar ask you after that?
She asked me if I could stand up.
Could you stand up?
No, I told her I couldn't stand up because of the accident.
What do you mean because of the accident?
I mean, my legs were jello. I was hurting from the crash. I was in shock. But I didn't feel like she believed me because she...
Objection, Honor, speculation.
May I be heard, Your Honor? This is not speculation. Ms. Lewis testifying as to how she felt about whether or not Officer Collar believed her, not as to whether or not Officer Collar actually believed her.
This sounds like it might be speculation. I'll let you get some more foundation to see why she believed that, but pending a motion to strike if I don't believe the foundation's met.
Yes, Your Honor. Would you like me to re-object at that point, or?
I'll keep up. If you think I miss it, you can remind me, but I think I'm going to keep track of this.
Yes, Your Honor.
Ms. Liu, you were mentioning that you did not feel like Officer Collar believed you. Can you please explain more?
Yeah, I felt that way because she asked me if the reason I couldn't stand up was because I had been drinking.
Were you in court a few minutes ago when Officer Collar testified?
Yes.
So as far as the motion as to speculation, I'll let it stand, subject to cross-examination, of course, that you want to cross her on that issue. I also think the fact that Ms. Lewis here suggests the officer doesn't believe her, so I'll let it stand as it is right now.
Yes, Your Honor.
Yes, Your Honor. Were you in court a few minutes ago when Officer Collar testified?
Yes.
Did you hear Officer Collar testify that she saw you at a gas station minutes before the accident?
Yes.
When you were at the gas station, did you have any trouble standing up?
No, I was standing up just fine at the gas station.
After you told Officer Collar that you could not stand up because of the accident, what did Officer Collar do?
She threatened to get a warrant for a sample of my blood, and at that point, I started to get even more scared.
How did you respond when Officer Collar threatened to get a warrant for your blood?
I knew something was wrong, so I asked her if I was being detained.
Were you?
Yes. She swore at me and said that I was being detained.
After Officer Collar told you that you were being detained, did she read you your Miranda rights?
I'm not sure. I don't think so, no.
Did she tell you that you have the right to remain silent?
No.
Did she tell you that anything you said could be used against you?
Objection, Your Honor. More prejudicial than probative at this time.
May it be heard, Your Honor?
Yes.
This is not more prejudicial than probative because it goes to whether or not Officer Collar was rushing through her investigation, which is an important fact to be determined here. And further, it is also probative of the manner in which she was conducting her investigation, which can go to Ms. Liu's state of mind when she was being interrogated.
Your Honor, may it be heard?
Of course.
Opposing counsel has already asked this witness if the officer read her Miranda rights, to which she said no. Now, to further go down this line of questioning, asking each question of the Miranda rights, now that becomes more prejudicial than probative because we already have that answer on the record. And to continue down this line of questioning, now that only goes to bias the jury against the officer.
I happen to agree with that analysis. I think it's enough that we know that the officer didn't ask her or read her Miranda rights. It's also not really relevant since we're not doing a Miranda hearing now. So I think we can, I'll sustain the objection and we can just move on.
Move to strike.
I guess the questions about the Miranda after the ultimate question of whether or not the Miranda rights was given, yeah, I will strike.
Yes, Your Honor.
Yes, Your Honor. After Officer Collar told you that you were being detained, did she ask you any more questions?
Yes, she kept asking me questions like if I had been around any drugs at the party.
What did you tell Officer Collar about what had happened that night?
I just repeated what Justine had said about the other person running up the hill, and I downplayed how much I drank. I didn't think it mattered since I wasn't the driver, and I didn't want to give her any more reason to be suspicious of me.
Why did you stick with that story about the person running up the hill?
I was drunk, in shock, frustrated by how she was treating me, scared about what might happen. I mean, I saw her laughing. I didn't want to change her story. And the police had spoken to Justine for such a short amount of time, I thought she would have stuck with it too. I was going out on a limb to protect her. But I never should have done that. It was a mistake.
Why was it a mistake to protect Ms. Chow?
Because Officer Collar told me that Justine blamed me and that they knew I had the car keys in my pocket. I should have just told them the truth from the start.
Did you tell Officer Collar how the keys ended up in your pocket?
Yes, of course. as soon as I realized what was happening, I told her the truth. I told her that Justine had given the car keys back to me.
After you told Officer Collar that Miss Chow had given your keys back to you, what did Officer Collar do?
She laughed, and she said that I had an interesting view of the truth.
How did you feel after Officer Collar laughed again?
I felt angry and sad and panicked. I knew what it looked like. And I felt from the way Officer Collar was talking to me that she wasn't going to listen to anything I had to say.
Thank you, Your Honor. Nothing further at this time.
Okay, thank you. Does the prosecution have some cross-examination?
Yes, Your Honor.
You may proceed.
Good afternoon, Miss Liu. I'm just going to ask you a couple of questions, all right?
Okay.
I want to make some things very clear to everyone here. The first question that the officer caller asked you when she arrived at that scene was, are you okay, right?
Yes.
You said, we're cool.
Yes.
And then without another question being asked, you said, we weren't the drivers, though, right?
Yes. I wasn't fully honest with the police when they first arrived.
That's right. Instead of being honest, you corroborated this story about a third driver, right?
Yes, I did.
And we all know here in court today that that is not the truth.
That's correct. I wasn't honest with Officer Collar when she first arrived.
But that's not the only time Officer Collar talked to you that night, is it?
No, she spoke to us separately afterwards.
That's right. She talked to you again when you were alone with her, right?
Yes.
And again, you told her that a third person was driving that night, right?
Yes, I know it was stupid, but I wanted to protect my friend.
I'm not asking you why you did it. I'm just asking you that you told her this story again, right?
Yes.
And again, this was not the truth.
It wasn't, no.
Now, before this accident happened that night, you were drinking, right?
Yes, I had some drinks at a party before.
And you said on direct examination that Justine, she smelled like alcohol too, right?
Yes.
You said on direct examination that you knew Justine didn't have her driver's license.
No, she didn't have it with her that night.
That's a yes to my question. You said on direct examination that you knew Justine didn't have her driver's license with her.
That night, yes, she didn't have it.
And you're telling us here in court today that you knew both of those things and you let your friend drive your car.
Yes, I was drunk and I made a mistake.
That's a yes to my question, knowing both of those things. You're saying today in court that you let your friend drive your car.
I did, yes.
Now, the officer also asked you about your drinking that night, right?
Yes.
And when she asked you how much you had to drink that night, you said you had 1 or 2 beers, right?
Yes, honestly, I don't remember exactly how many drinks I had, but I did downplay it to Officer Collar.
That's right. You again told the officer not the truth.
Yes.
And even though you're saying you weren't the driver, you still downplayed to the officer how much you had to drink that night?
Yeah, like I said earlier, I didn't want to give her any more reasons to suspect me, so I downplayed it.
Let's talk about some things that we know are the truth today.
Okay.
The car that crashed that night, it's a Ford Fusion.
Yes.
It's registered to you.
Yes, it was my car.
It was registered to you on June 21st, 2021.
Yes.
And because it's your car, you have keys to it, right?
Yes, I did have the car keys in my pocket after Justine gave them back to me.
At the end of that night, on June 21st, 2021, the keys to that car were in your pocket, right?
Yes.
Thank you. No further questions.
Do you have any redirect?
Yes, Your Honor. Ms. Liu, I'm just going to ask you a few more questions to follow up. So can you first explain to the jury who was the first person to tell the police that somebody had run up the hill?
Justine was the first person to say that.
Why did you stick with that story about the person running up the hill even when you were alone?
I was drunk and I wanted to protect my friend, and I thought that she was going to go along with it too.
By the end of the night, had you told Officer Collar the truth about what happened?
Yes. As soon as I realized that Justine was blaming me, I told her the truth. I told her everything that happened that night.
Thank you, Your Honor. Nothing further. The defense rests, and may the witness be excused, please?
Yes, of course.
Thank you,
Thank you, Your Honor.
So we'll give you 5 minutes before closing arguments to kind of get your thoughts together. Sound good?
Yes, Your Honor. Can we also check in with the bailiff at this time?
Please, please.
Yes, the prosecution has 30 minutes, 35 seconds remaining, and defense has 22 minutes, 10 seconds remaining.
All right, you can take a seat. And so we'll resume the trial, and we'll have the prosecution go first with their closing argument. Okay. Okay.
Your Honor, may I proceed?
Yes.
Her car, her keys, her crime. We are here today because of the defendant. On June 21st, 2021, the defendant told her friend she would be the designated driver for a fun night out. Instead, she had drink after drink after drink. She got drunk enough that her blood alcohol concentration was almost 3 times the legal limit. She got drunk and she got behind the wheel with her friend in the passenger seat. She got drunk and she drove her car 85 miles per hour, crashing and causing her friend, Miss Justine Chow, to break her ankle. We are here today because of the defendant's decision to drive drunk. This was her car, her keys, and this was the defendant's crime. Now, the people have the burden of proof in today's case. We had to prove to you that the defendant operated a motor vehicle while intoxicated and injured someone in the process. And we had to prove this to you beyond a reasonable doubt. We did not have to prove it beyond any doubt. We did not have to prove it beyond all doubt. We had to prove it to you beyond a reasonable doubt. And while the defense has tried to raise doubts in your mind today, provoking speculation and guesses about what happened that night, these doubts are not reasonable. Now, let's talk about the charges the people have brought in today's case. There are 2 charges. 1 for aggravated driving while intoxicated, and 2, criminal vehicular operation. Now, all that means is that we had to prove 3 things to you today the first two of which are already agreed upon by the people and the defense. First, that the defendant's blood alcohol concentration was over 0.16. Check. Both parties have stipulated to that in today's case. Second, that someone was injured in the accident. Check. Both sides agree that Miss Chow broke her ankle that night. 3, that the defendant was the one driving. Check. We have proved that to you in today's case. Members of the jury, if you find beyond a reasonable doubt that the defendant was the one who drove that night, she is guilty of both charges. Now, I want to review the evidence in today's case. You heard from Officer Jean Collar. She's an expert in DWI investigations and has aided in over 500 cases of driving while intoxicated. You heard that based on her extensive training and experience and what she saw that night, she determined it was the defendant who drove. The officer arrived at a chaotic scene. A car was engulfed in flames. You heard from both sides that this was scary. The officer's first priority was making sure that both people who were in the car were safe. She asked both of them. Her second priority, finding out who drove the car. She talked to both suspects together and then apart. Miss Chow immediately dropped the defendant's story about a phantom third driver as soon as she was separated from the defendant. As soon as she got some space from her drunk, angry driver, she was able to tell the truth. You heard that Miss Chow didn't even have a driver's license, so the defendant was supposed to be the designated driver that night. You heard that it was the defendant's car, a car she drove drunk, crashing and causing Miss Chow to break her ankle and lose her heel in the passenger seat of the car. You heard that at the end of the night, the keys were still in the defendant's pocket. Members of the jury, all that is left are the distractions made up by the defendant under the pressure of a burning car and blaring sirens maintained to you today in this courtroom. The defendant wants you to believe that despite it being her car, her keys, her story about a phantom third driver, that somehow someone else is to blame. The defendant wants you to believe that it was actually Miss Chow who drove that night. That she let Miss Chow drive her car when she knew Miss Chow was drunk, didn't have a driver's license, but still the keys were in the defendant's pocket at the end of the night. Members of the jury, ask yourself, is this story and the doubts it is designed to give you reasonable? It is not. The only reasonable conclusion is the one supported by real evidence. The car, the keys, Officer Collar's testimony to you today, Miss Chow's statements, the blood alcohol concentration test confirming the defendant's drunk escapade, the burning car, the broken ankle. The only reasonable conclusion is that the defendant is guilty. Members of the jury, we are at a fork in the road. Down one road, we do not hold the defendant accountable. We tell her that it's okay to drive drunk. We tell her that as long as she makes up a story, tries to keep the truth of what happened from the police who are just doing their job, that somehow she can walk away. The defendant wants you to find that she is above the law. Down the other road is accountability. Showing people that their actions have real consequences. That night after the crash, Miss Justine Chow said, "Oh my God, I can't believe I'm alive." The next person might not be so lucky. That is why we hold drunk drivers accountable. It was her car, her keys, and this was the defendant's crime. Now, it's up to you to decide whether to walk down the road of accountability. Find her guilty. Thank you.
Defense has a closing argument.
Yes, Your Honor.
May proceed.
Your Honor, members of the jury, counsel, may it please the court. Convenience over justice. On the morning of June 21st, 2021, this case was opened and this case was shut. In less than an hour after the police arrived at the scene of the crash, Jackie Liu was in handcuffs. By the time the sun rose that morning, they had their villain, they had their story, and nothing was going to stop them from trying to convict Jackie Liu. But they were so laser focused on Ms. Liu that they didn't ask the tough questions. They didn't collect all the evidence. Throughout today's trial, we've heard about the loose ends the police didn't tie up, about the leads they didn't pursue, and if there's one thing that's clear, it's that they chose convenience over justice. We learned a lot throughout today's trial. We learned who Jackie Liu really is. She's a 29-year-old graphic designer here in Eureka. And we learned she made some mistakes. She got caught up with the wrong friend. She trusted the wrong friend. And we heard what her first instinct was after surviving a crash to protect her friend. She told you she could have told the police the truth from the beginning, that I wasn't the driver, but instead she said we weren't the drivers. She protected Ms. Chow. And we also learned what Ms. Chow's instincts were. She lied at every step to protect just herself. But what we didn't learn is that Jackie Liu drove drunk on the morning of June 21st, 2021. Now, as Judge Abram will instruct you, that's exactly what this case comes down to. And it wasn't enough for the state to tell you that it could have likely been Jackie behind the wheel. It wasn't even enough for them to tell you that it was likely Jackie behind the wheel. No, they had to definitively prove to you, beyond a reasonable doubt, that the person who drove drunk on the morning of June 21st was Jackie Liu and no one else. Members of the jury, they couldn't meet that burden. Because as we learned today, this wasn't a normal DWI investigation. The police didn't see someone driving unsafely, pull them over, walk up to the driver's side window, and give them a field sobriety test. This wasn't a normal DWI investigation, because when the police arrived to the scene of the crash, it wasn't clear who the drunk driver was. There were two suspects. An officer caller told Jenna on the stand, she said that when I got to the scene of the crash, both Ms. Liu and Ms. Chow were sitting at the curb away from the car. And so with two suspects, and in the absence of seeing who was driving, Officer Caller told you it would be ideal to have an eyewitness. And the state told you they have an eyewitness. Well, the problem is that eyewitness is a suspect herself. And Officer Caller, she had the chance to get an eyewitness account from someone who was reliable, a third-party eyewitness, but she chose not to. You heard her tell you that she went to the gas station, she saw security camera footage, and when she couldn't get that footage, she didn't ask a single follow-up question. Didn't give a description of Ms. Chu to the gas station manager, didn't give a description of Ms. Liu to the gas station manager, didn't ask her if she saw who drove that car into the gas station or out of the gas station. She chose to look away. The truth is, in the absence of a thorough investigation, the state cannot tell you who was driving on the morning of June 21st. So I want to walk through the evidence and tell you what the police could have found had they conducted a full investigation instead of doing what was convenient. Because think about how convenient it is for the state to tell you that Ms. Chow's shoe was found in the passenger seat. Because you know that's not true. All Ms. Chow did was tell the police her high heel was lost in the passenger seat, and the police believed her. But what reason did they have? When I asked Officer Caller on cross-examination, did you push back on this claim at all? Her answer? No. No follow-up questions, despite the fact that there was no physical evidence to corroborate what Ms. Chow said. No follow-up questions, despite the fact that everything in that car was destroyed beyond recognition, turned to dust in her own words. So how can the state get up here and tell you that that shoe was lost in the passenger seat? And members of the jury, think about what happens when someone decides to drive with high heels on. They take off their right heel so they can operate the pedals. And recall what we learned about where Ms. Chow's injury was. To her right ankle, the same ankle that would have been extended against the pedals and would have absorbed the impact from the crash. Now, we could have so easily corroborated this information, confirmed this narrative, had Officer Caller taken 1 second, asked a single question about which shoe Ms. Chow was missing. But she looked away. Now, even though she was a suspect, even though she was drunk, Officer Caller never once asked Ms. Chow where she was coming from, how many drinks she had that night, never asked whether she had taken any drugs, never asked her to submit to field sobriety tests, never asked for a sample of her blood. To this day, the state cannot provide you any evidence showing what Ms. Chow's BAC levels were on the morning of June 21st, 2021. Officer Caller is a seasoned investigator with over 500 DWI investigations. The state offered her as an expert in this field. So she certainly knows the importance of collecting that information within the 2 hours required by the law. So when she looked the other way, when she concluded her investigation in less than an hour, you know she wasn't searching for justice. She was doing what was convenient. And we can't go back. That evidence is lost forever. The state is stuck. They have to stick to what's convenient. Now, Ms. Watson just got up before you and asked you whether what we're telling you is reasonable. Members of a jury, every question the police didn't ask, every answer the state couldn't give you, every piece of evidence that's missing from today's case is reasonable doubt. And there are many of those. The state has not met their burden. And so I want to take a second to address the case that the state presented. Because both Counselor Grayzel-Ward and Ms. Watson told you that what we're trying to do is, well, distract you. You know that's not true. you know that we focused your attention to the deficiencies in the state's case. Of course, they want you to think that those deficiencies are distractions. So I'll come back to the question my colleague Ms. Alpern asked you at the beginning of today's trial. Did the state present any evidence that places Jackie Lou in the driver's seat? No. Bless you. All they told you was that it was her car and it was her keys. So let's take those things one at a time, starting with the car. All they told you was that the car was owned and registered to Jackie Lou. Members of the jury, that's hardly proof. People borrow each other's cars all the time. And you heard from Ms. Lou on direct examination, that's exactly what happened in today's case. Ms. Chow convinced her she was good to drive and then got behind the wheel of a car that wasn't hers. That's not proof beyond a reasonable doubt. Then they relied a lot about those keys that were found on Ms. Lou's pockets, but I want to remind you how those keys ended up on Ms. Lou's pockets and how the police knew they would be there. Because throughout today's trial, the state constantly said that at the end of the night, those keys were in Ms. Lou's pockets, and that's correct. Because at the beginning of the night, that wasn't true. Ms. Lou told you on direct examination, she told the police, she told you that Ms. Chow tried to hand those keys back to her, and she took them. She thought to herself, why wouldn't I? Why would my friend hold on to the keys of my totaled car? So as Jackie Lou put those keys in her pocket, Ms. Chow watched. And at the first instance, she used that fact to save herself. And Officer Collar corroborated on the cross-examination as well. She told you Ms. Chow was the one who led her to the exact location of those car keys. Not just that they would be on Ms. Lou, but that they were inside of her pocket. That the keys ended up on Ms. Lou at the end of the night is not proof beyond a reasonable doubt. So in the absence of any conclusive physical evidence, the state relied a lot on Ms. Lou's attitude during her interrogation. In fact, Counselor Grayzel-Ward's entire cross-examination almost was certainly about that. And I want to remind you that that interrogation occurred without Ms. Lou being Mirandized, another big oversight from a seasoned officer. And Ms. Lou told you how she felt during that interrogation. She told you just how disoriented she was after barely surviving a massive crash. She was covered in blood and glass. Next to a burning car, she was hurt in severe shock. She was relieved to see the presence of the police so that maybe they could help her. But instead, they laughed at her. Instead of listening to her side of the story, they dismissed everything she said. Members of the jury, you can hardly blame Ms. Lou for being panicked or distrusting the officers who laughed after one of the worst moments of her life. Her attitude is not proof beyond a reasonable doubt. Now, Ms. Watson told you there's a fork in the road, and we can go down either path, accountability or letting the defendant walk free. But the two paths that we have in front of us are justice and convenience. And we've shown you which path the state has taken throughout today's trial. Now, after all this talk about burdens and proof, you might be asking yourself, why beyond a reasonable doubt? There's a reason why this burden is so high, and it's an important one. Because sometimes the system fails. Sometimes someone is in the wrong place on the wrong night and trusts the wrong person. Because sometimes a biased accusation and a few unlucky circumstances are all you need to be put on the witness stand. Because sometimes, when the facts are looked at from just the right angle, with just the right preconceptions in mind, they seem to line up behind the wrong suspect and the wrong story. That's why convenience is not enough. Guesses are not enough. Presumptions are not enough. Because the law says that in a case like this, the only presumption you must make is innocent. Jackie Lou is innocent until the state proved her beyond a reasonable doubt to be anything but that, and they failed. Members of the jury, don't choose convenience. Choose justice. Find Jackie Lou not guilty. Thank you.
Thank you. Do you have rebuttal?
Yes, Your Honor. Your Honor, members of the jury, it was not convenient for Officer Collar when she came upon a burning car on the night of June 21st, 2021. It was not convenient for her to find out what really happened when the defendant did everything she could to keep the truth from coming out. On direct examination, the defendant said she thought there would be no way for the police to find out what happened. This is what Officer Collar was dealing with, not a situation of convenience. It was not convenient for her to find justice. But, Your Honor, members of the jury, today's case is not about convenience over justice. It's about fact over fiction, fact over distraction. The defense just got up here and gave their closing arguments, again distracting you. The defense wants to train your attention on what happened at a gas station before the accident even happened. The defense wants you to train your attention on what happened with a shoe that was in flames. The defense wants you to train your attention on whether or not a BAC test was done of Miss Chow, who is not on trial today, who Officer Collar told you she knew was intoxicated. These are the distractions that the defense wants you to pay attention to. But I want you to pay attention to the facts. When Officer Collar arrived at the scene of the crime, she tried to get justice. She did a thorough investigation, talking to both suspects together and one-on-one, and she came to the conclusion that based on the fact that Miss Chow did not have a driver's license, that she immediately told the truth, whereas the defendant continued to lie, that based on the car being the defendant's, the keys being in the defendant's pocket, that this was the defendant's crime. Members of the jury, Your Honor, this was not a convenient investigation. This was not a convenient trial, but we can still get justice as long as we pay attention to the facts and hold them up over the distractions. Members of the jury, find her guilty. Thank you.
Great, thank you. I guess that means the trial will resume or will end. And I think we need to take a few minutes to confer. But I think there's announcements for all of you while we confer.
Hello, everyone. My name is Leah Walker. I'm one of the student directors for Bales, and this is...
Hi, I'm Liz Mooring. I'm the other student director for Bales.
Can we give another round of applause to these competitors for their beautiful performance? So Liz and I are here today to present the Outstanding Attorneys and Outstanding Witness Awards. These are awards that are tabulated actually during the preliminary rounds where the judges were able to say who their top attorneys were for that particular round. There are 2 top attorneys. Oh, and by the way, this is open to all of the participants of the competition. There were about 24 people who competed in Bales as a whole, so it's not limited to these 4 up here. And the 2 outstanding attorneys are, as I open the envelope, two outstanding attorneys are Rana Nagia and Andrew Johnson. They are not here, but please give them a round of applause.
And our outstanding witness goes to Maya Shuker. Congrats. And next, we will have our trial team director, Dario, come up and say a few words about recruitment season.
Hi, everyone. Thanks again for coming. We're so glad that you're here. And again, amazing job to these 4 advocates, but not just to them, also these amazing witnesses. These guys are also great, carried it through. Good job. And now, aside from the people who are here competing, is there anyone in the audience that I don't know that's a law student? Okay, great. Well, I'll do a little recruitment pitch, but first, just to give everyone some context. So my name is Dario Maciel. I'm one of the student directors of the trial team. The other student director is sitting right there. He's Brian Anderson. So Brian, raise your hand. Sitting right next to him is another member of our trial team, Wesley Dunkirk. So if you could say hi as well. And then Liz Mooring is also on our trial team. And then in case you didn't know, those two are actually the Bales champions from last year. So they were right in their shoes. They did an amazing job just like these competitors did. And so we're really proud of them. They've now taken on the mantle to run this competition. So we're very grateful for them. So give them a round of applause because they did an amazing job. So again, thank you to Liz and to Leah for doing this amazing job. And then also Evie back there, who is the unsung hero of the entire competitions program, putting together the logistics. We're incredibly grateful to Evie as well. So then, what does trial team do? Basically, we do what you just saw these 4 people do. So trial team is a student group. We develop the trial advocacy skills of the people in the program. And whether that's people who just love doing mock trial, there's people who've done mock trial in high school, college, there's people who want to get involved for the first time. There's folks that want to be trial attorneys, so they come to the program so that they can develop the skills that you just saw these 4 people perform. So we do what you just saw in this courtroom today, but we do it externally. So while this is an internal competition that's open only to 1Ls, first-year law students, the trial team is an external competition program where we have a class that teaches advocacy skills. We have coaches that come and teach trial advocacy skills for each team that we send out. And then those teams go out there, compete against other schools, and develop their trial advocacy skills in the process. So here's the pitch, and I'll make it brief. I am amazed by the skills that everyone here has shown. And so primarily this is a way for us to pitch to you 4 that please, please try out for the trial team because you all did amazing. And if this is something that interests you and you want to develop trial advocacy skills, if it's something where you just never thought of being a trial attorney and now you're considering it, or you know that that's not for you, but you loved what you did here and you want to do some more of that and develop your public speaking skills, your performance skills, then we definitely invite you to try out because what we saw here was amazing. Same thing for our witnesses, same thing for the other law students here. And if anyone who's not a law student wants to come and be a part of it, you're welcome to do it too. The more the merrier. So, and also want to emphasize that the people who put on this program is the BOA. So that's the Board of Advocates. They run a bunch of different competition programs. So it's not just trial team, it's also the moot court program, which does like appellate advocacy. You write a brief, you present oral arguments to a panel of judges. There's an ADR team that does negotiations, and there's IP and tech. There's IP and tech, they do stuff related to IP and tech litigation. So patent prosecution, yeah. And I don't know what that means, but but it's not in my wheelhouse. But suffice to say that there's a lot of different advocacy programs for any type of legal background that people are interested in. So if it's not trial team, we understand we all make mistakes. We don't always make the best choices. You're free to also choose one of the other programs as well. So again, just a plug for the amazing work that the BOA does to promote advocacy skills at Berkeley. It's something that we really pride ourselves in. It's something that we love to see people develop. And I can guarantee you that, everyone here who you saw today started from somewhere, and now they're that much better because they've gone through this process. And that's what the advocacy competitions do. So again, now I'll shut up and I'll hand it back over to our directors. But again, thank you all for being here. Amazing job, U4, U6. That was so fun to watch, and I'm so glad that we got to be here and watch you perform so well today. So congratulations to you all.
Okay. Thank you, Dario. Please enjoy this brief interlude while we wait for the judges to come back from their conference.
You may be seated. Thank you. So I thought at this point we'd give you feedback. I was thinking we just individually give all of you feedback on the trial and on your individual performances, and then there will be the results of the competition. So my name is Leah Abraham. I'm currently a district attorney in Alameda County. I used to be a public defender in Alameda County for several years. So that's my background. I've done both sides, so it was definitely entertaining to see both sides at work. So let's just, I guess, go point by point. So first of all, I would just say overall, all of you performed very well. In my opinion, you have a very professional demeanor. I could easily see any of you all in a courtroom tomorrow. And so I think in any ways that you're interested in doing trial work, I think all of you really have the skill sets to be really, really good in trial. So don't at all be intimidated. You can match up with anybody right now. So let's start with the opening statement by the prosecution. So I thought overall, of course, you had a very good demeanor, and you had confidence, and you had passion. I think an appropriate amount. You don't want too much from the prosecution because you don't want it to seem like you're taking it too personal, but I think you had an appropriate level of passion and persuasion. I would think at that point, so in an opening, you kind of want to have a theme, and I definitely remember your theme. And I think, though, that your theme, I think, is for each side, right, for the prosecution is kind of why the person is guilty. And I think, well, it's clear on the prosecution side why you think, I think it made sense in the sense of like why you thought the defendant was guilty based off that theme, because that's what you focused on throughout. So in that way, it was consistent. I do think, though, you could focus, I think, what was going to be the pertinent question in the trial, which was who was driving the time of the accident. So it's clear that you feel like it's her car, her keys, her crime, right? But I think you have to remember that why we're here, right, is not because whose car it is and whose keys it is and where it was found. It's who in the world was driving at the time of the accident, and that's what they're going to distract us with. So I think you want to make sure you focus on that and make that. I think that when you do that, I feel like when you're able to kind of imagine what the defense is going to say and have an answer always, because you have the benefit of always going first. That's quite powerful for the prosecution because you already have, it is your burden. But I think if you can already imagine everything that they're going to say and have an answer before they even get to say it, that's pretty damning on your side. So I think just making sure that your theme goes to the ultimate question. And so to your opening, I thought it was a very strong opening. I think it focused on the pertinent issue, which was who in the world was driving that night into the morning. I would say, though, that the use of the word innocent is a very strong word to use. I have used it before when I was a defense attorney. I don't think it's not always inappropriate, right? But I think in a case where it's truly a not guilty kind of case, right? Whereas like your argument really is she's not guilty because you don't know what happened that night, right? Because I think it's a bit much to ask a jury to believe your defendant wholeheartedly, unfortunately. You're very endearing, but you lied. You lied a lot. So, so to say she's innocent and she's like, just believe her story wholeheartedly, you don't have to ask the jury to do that. All you have to ask them to do is say, can you, with abiding conviction for the rest of your life, which was what abiding conviction means, right? You believe it for the rest of your life. Do you believe she's the driver? I don't think that is a tough lift for this jury, right? But I think when you use the word innocent, then they feel like, I have to think she's innocent. And you don't have to think she's innocent to believe it in this case, like to vote not guilty, right? So then prosecution witnessed the officer. I thought you pivoted pretty well with the exhibits not coming in. I think, I think like you just did a very good job of being, okay, well, then we're just gonna move on, and you got in all of the things. So you still got in that it's this fiery accident, and so, to your credit, great, right? I thought the witness was very good, performed very much like a police officer. A little smug, but accurate. I really felt like I was actually in a courtroom when you were testifying. Like that kind of like, I know I didn't do all the investigation I can, but who cares, Like, it's making you question whether or not you have a right to ask them a question. So I liked that. I thought you did the acting very well. I assume you're not smug in real life. And then I thought your cross was very good of the police officer. I think you did a very excellent job highlighting the lack of investigation, right? And I thought you made a big thing out of the gas station, which I imagine it wasn't like the hugest thing in the fact pattern, but you just kind of developed into something like, because it makes the jury, if the jury, and I think you could tie this to your closing, if the juror is thinking, well, what did happen at that gas station? If you'd like to see a video of what that was happening at that gas station, you have a reasonable doubt, right? So I think you could have made that point. But, I thought overall, though, very good job, highlighting that there was stuff that the officer could have done to kind of close that loop a little bit. I will say, though, as to your cross, the fact that the car is turned to dust is a fact that actually is helpful to the prosecution because they couldn't have figured out the shoe situation, right? Because it was a fiery. So I think you were right to try to get out the photograph of the fiery car, but then I think to develop that further went against your interest, right? That is kind of a reasonable explanation. I got to give it to the officer that they didn't go look for the shoe. And so then, sorry, I'm going past my 5. I'm sorry. I'll hurry up. I thought that the defendant or the witness did very well. You were very sympathetic and endearing. I would say that, as far as you kind of asked her, well, why was it a mistake to go out on a limb for Jew? I think the answer to that is it's not, I shouldn't have lied to police officers in a pending criminal investigation. Not like, oh, my damn friend, she's not nice, is she? That's not, it was not quite what I was looking for, so it kind of seemed she didn't seem very contrite. I was wrong to help my friend out. That's not the point. You shouldn't have lied. And so then for Attorney Ward, your cross was very short. I think you could have developed more because she did lie on multiple occasions, and I think you could have developed that more and make her say it out of her mouth. Yeah, I did lie about that. I did lie about that. So I think, because I think that is a benefit to your side, right, is that she lied a lot. And then closing arguments, I thought you both did very good jobs. As to the prosecution, I would just say, I think there's a lot of conclusions about why she's guilty, but not so much guiding the jury to why, right? You want to guide them. You want to explain, take them on that journey of, okay, yes, she's guilty, but here's why these are not reasonable. You don't want to make the conclusion for them without anything else, right? And so it's clear that you're confident she's guilty, but you got to help them get there to your level of confidence, right? Really just, I think, yeah. And then into your closing argument, I thought you really highlighted a lot of the weaknesses in the investigation, and I think there's some ways you could have woven in some things like the gas station, right? If you want to see that video, and I think you have a right to take a little umbrage, of being characterized as trying to distract the jury, right? If they're gonna fight with fire, then you can fight back and say, hey, that's not what the Constitution says my role is to distract people. It's not a distraction. These are valid points that they have no answer for, right? So I think you can respond back in kind like that. I think, and it's a risk to call them a distraction. Sometimes it works a lot of the times, but just making sure that you use those kind of words if you really think that they're weak, their case is that weak. If it's more strong, I think you have to take it a bit more seriously. And then, yeah. Judge.
I'll move over here so that I can see Samahria. Okay. I don't feel like I need it. If you want me to, I'm happy to. Okay. Great. So first off, I want to thank everyone. You had an incredibly prepared presentations. It was really exciting to watch y'all, and I completely agree with Judge Abraham that you could walk into a courtroom tomorrow. This was really excellent, and you should all be really proud of yourself. My name is Cecilia Fierro. I'm a public defender in Contra Costa County. Recognize a few of you here in the classroom. I am a felony trial attorney. I've been doing trials since I started. I was an intern, I was a graduate law clerk, and I've stayed at Contra Costa, now in a felony trial rotation for 6 years. We do a lot of trials in Contra Costa, so if you're interested in doing trial work, I really encourage you to come talk to me, come intern at our office. I'm in the middle of a 2-month-long trial right now, so I have lots to say about that. I'll parse it down based on the sections that y'all went through, and I'll try to be brief, and I won't repeat what Ms. Abraham said. Bex, for your opening, I thought it was incredibly strong. Your presentation was confident, and you walked into the well presenting yourself as an authority for the jury to listen to. You have to admit that I think the prosecution's left with a pretty limited and reductive case. I think you compensated for that, right? Yeah. With your confidence. Just moving forward, because I'm sure y'all are going to be doing trial teams next year, what I have seen in practice is that in these sets of circumstances, often I find that a softer case presentation, one that even embraces what's missing, can be a little bit more effective. But as far as what you laid out, it was absolutely excellent, incredibly well organized, great discussion from the outset of the charges and the elements. And using your arguments as a teaching moment to your jury is so important, because this is all new to your jurors. They're going to be intimidated with the process. They want to make the right decision. And when you spell it out for them step by step like an instructor, you're, again, positioning yourself as the authority that they're going to want to listen to because you make it clean. For Samahria, I thought that your opening was a rebuttal, not only in context, but also in presentation, and that was really exciting, right? We've got Bex over here, like slamming on the witness stand, and you come in, again, super soft, very calm. You weren't moving around a lot, and your case is more nuanced. I was really impressed, and I think it's harder for law students to present on a case that's outside the four corners of your case packet. I think that's hard in general and it is the primary role a lot of the times of defense attorneys. And that's exactly what y'all did. Your entire case was the logical things that aren't missing. It's more nuanced, and you presented it in a calmer, more nuanced way that made us think, oh, especially when you associate that with the burden of proof, with like reasonableness, it is really reasonable to be asking these questions. And look at this calm person who's talking to me in such a nice way. She's reasonable. I want to be reasonable too. I completely agree with Leah on the use of the term innocent, because remember, and I'm sure you'll know this, but you're not going to be ever seeing a jury form that says guilty or innocent. It's guilty or not guilty. And I know we can talk about presumption of innocence, but that's usually not a phrase I like to use with my jury, because I think it then sets the defense up for a higher burden of proof when we shouldn't have one at all. Back to Lande on your direct of the officer. I thought you laid a great foundation for an expert. Sometimes that can be a little clunky, and it was absolutely seamless in the way that you did that with the officer. I think you did a good job responding to objections. That can be tough because you don't know entirely what to expect, and that was solid. I liked your questioning style, number one, all of you actually, so I'm not going to be redundant, but everyone had an excellent pace. I'm a fast talker, as you can see. Y'all aren't, and that makes it really easy to absorb relevant evidence as it's coming in. Great repetition in your questioning of the bad facts that came out with the witness. So you use those like questioning moments to reiterate your theme. Oh, give me more. So the defendant didn't give you any details about this mysterious third driver. Let me ask you another question on that, right? You're using your questioning kind of as an opportunity to give your own testimony and to incorporate the theme of your case, and that was really nice. Counselor Mandani, I loved your start out to your cross immediately from the outset, demonstrating the big picture. I hadn't really considered the perspective of how quick this investigation was. We knew it from the substance, but not from the time frame. And I thought that was a great opportunity for you to really bring the jury in as we're like viewers in this story. And now we're invested because we're considering it in the conception of time. Great engagement with the jury, looking at us while questioning. Again, this is all a performance. And I felt like certainly I'm like really interested in how you're responding to the witnesses' questions, which shouldn't be my focus at all, right? I need to be invested in the officer, but I was invested in you, and I thought that was exceptional. Again, like I mentioned with the defense, great presentation of your case outside of the four corners of the report. This was tough because you have a limited case packet, and you're never going to know what evidence is going to be admitted. So, like, careful. I think I definitely saw what you were going for, but in the beginning, I wasn't sure if you had like remembered at that portion that the exhibit actually hadn't been admitted, but you pivoted so well. It was great. You got in exactly what you wanted, and that was impressive. Your Jackie Liu, the name of the witness is actually after a friend of mine, Janice Liu. I don't know if anyone knows her. So that was exciting to feel like I'm seeing Janice, and this is exactly something that Janice would do. But a great humanization of your client. Again, I thought it worked well with your theme, and you kind of have a very soft tone, and that was nice because we did want to learn about her, and accepting her as a person is part of us accepting your defense. A very clear roadmap of what you were going to be discussing. Again, always great pacing and tone. And I really hadn't, when reading this, thought so much about how the defense how Ms. Liu's demeanor is a direct response to the officers kind of chiding her and looking over her, disrespecting her. And I thought that was an excellent point that y'all picked up on, and you portrayed that to the jury very, very clearly. Also, through your multiple check-ins. How are you feeling at this moment? Tell me why. How are you feeling after that derisive comment? Tell me why. It was very, very effective, and I thought you had incredible responses to the objections, especially the one regarding, I think, the officer's demeanor, exactly that. You said, not only is it our witness's state of mind, but also the DA already opened the door to it. So let's go. So that was great. I'm over time. So did I give everyone direct feedback? I think I did. Excellent work, all of you. I would love, love, love to talk to you about coming to work in our office. I know you're already doing work with us, but you should all be very proud of yourselves, and congratulations on a great performance.
Hi, everyone. My name is Jenna Forster. I am an alum of Berkeley Law. I'm now an associate at a plaintiff side firm where I do affirmative government litigation. And I'm also one of the co-head coaches of Berkeley's Trial Advocacy Competitions program. So I very much hope and expect to see all of you at tryouts this year because you're all exceptional, and we would love to have you as members of the trial team. So as for this trial, let me say, first of all, what an honor for me to be on a panel with these amazing, distinguished judges, and also to get to watch all of you in what was truly a phenomenal Bales final. I mean, the things that we saw from you all today in terms of adapting to what was going on in the round, arguing objections, like you've done this 1,000 times. I have seen advocates with much more experience than you who do not have the confidence and command of the courtroom that the four of you displayed today. So you are absolutely to be commended for putting in all the work to prepare this trial when I know you're 1Ls and there's like a million other things going on. So kudos to you for all of that. I touched already on a couple of the things that I think everyone did really well. Objections were argued fantastically. There was not really a moment where any of you looked like you didn't know what you were going to say. There were probably moments where you felt like you didn't know what you were going to say, but you did an excellent job of faking it till you made it, and that is really fantastic. And to go along with that, you adapted really well, both in objection arguments and then to what the witness is saying, to what your opposing counsel is saying. There was some really fantastic use of the other side's words in opening statements and closing arguments, even in exams of the witness's words. So that's all really to be commended. I think both sides had really good themes and theories that crystallized the case. This is our job as advocates and trial lawyers, is to take a really complicated set of facts and pull from that a really simple distillation and a story that we can tell the jury. And we can tell the jury, this case is about this one thing, focus on this. I think both sides did that well. I think the themes on both sides were easy to remember and were repeated throughout and were woven into your proof as well, which is fantastic. I do think on both sides, because your themes and theories were so crisp and so tight, there were moments in your cases in chief where there were details that you didn't really need. And the problem with that, I always think less is more, right? Because the problem is once you start getting into these details, every detail that you tell the jury is something that has to be explained. And it gets tricky because you as the advocates know the case so well. You know all the facts. And so sometimes you go a little bit too fast. You rush us. You say things almost as if you're arguing with each other instead of explaining to us. And to your point, Cecilia, about being a teacher and really, getting to bring the jury along with you step by step. The more facts that you're trying to show the jury, the less time that you have to prove each one up in a way that really sticks in the jury's minds. So that's something to think about in terms of, I like to, when I'm writing an exam, go back through every single question and ask myself, do I need this question? Do I need that question after every single one? So that's something you all should think about. And the last general theme I will touch on is in the same vein of needing to command the jury's attention throughout, in this case, an hours-long trial. When you get out into the real world, days, or in your case, months-long trials, how do we do that? How do we keep the jury's attention? And you all are already so good, you already have all the basics, that I don't have to tell you, stop doing this, don't do this. I get to tell you, how about try this? Like, how about think about adding this tool to your toolbox? And so the tool I want you all to think about is variation. And this looks like a lot of things. I think variation in tone is a big one. The four of you are so confident already, which again is something that should take many more years to accomplish at the level that you're already doing it. And so that means that everyone has this great default, confident, loud in a good way presentation. And so in order to develop variation now, to keep the jury's attention, we should add in more soft moments, more pauses, more silence. And there was some really good use of that, and there is always room for more. So think about that. And another example, a variation on the theme of variation, is to think about how you're asking questions and answers. There was really good consistent use of open-ended questions on direct and leading questions on cross. But think about what exactly the answer is that you're looking for, and not just in substance, but also in format and length. The most powerful form of answer that is going to stick the most in the jury's mind is a one-word answer, a yes or no. So think about when you're writing a direct examination. Are all of my questions open-ended such that the witness will answer them with a paragraph in response? Because if so, some of that paragraph is going to get lost for me, the listener, for me, the juror. So if there's a point that you really need to emphasize, think about asking a question. Maybe it's not a leading question, but a close-ended question, somewhere in the middle between open and leading, that gets us a one-word answer that's really gonna latch itself into my mind. And then you're gonna follow it with a nice long pause, so it stays there. Again, these are all things that we get to build on, we get to play with now because you're already at such an extraordinary level. Both teams absolutely deserve to be here. Credit to your witnesses, to your coaches, to everyone who's helped you get here, and congratulations.
All right, everyone, could we have just a huge round of applause for our finalist teams? My name is Natalie Winters. I am the director of Berkeley Law's Advocacy Competitions program, and myself a very proud alum of the Berkeley Law trial team as well. It gives me a great amount of pleasure to announce the winning team for you. I'm just gonna grab my program real quick. You all truly did a phenomenal job, and this was not an easy decision for our judges. I would just echo what I know you've already heard from three very experienced practitioners themselves, but I hope that you do, no matter who wins the final round, really consider what trial advocacy might hold for you in the future, because you're all incredibly talented and should be very proud of the hard work you put in to get here. The winners of the Bales final round are Samahria, Alpern, and Leah Mandani. Congratulations. And a round of applause for our finalists, Bex Grayzel-Ward and Lande Watson. Thank you so much to our judges. Thank you so much to our audience members, our coaches, the Berkeley Law trial team, which does so much to help train these advocates, help score some of our preliminary rounds. We hope to see many of you at another competition or at tryouts for the trial team, which will be at the end of the spring. I hope you have a great Sunday evening. Take care.